Okay, everyone, we continue with this session on constructing narratives and identities, and we have a paper here from Yannick and Brink on juvenile detention, decisions, and interprofessional dynamics in juvenile justice in the Netherlands. Thank you.
Thank you. Yes, well, good morning still. I would like to share some of my preliminary findings of my doctoral research on the use of pretrial detention in the Dutch juvenile justice system, with a particular focus on the interprofessional dynamics that lie at the heart of these pretrial detention decisions and the use of alternatives to pretrial detention. The outline of my presentation is as follows. First, I will provide a brief introduction to the Dutch juvenile justice system and the position of pretrial detention within the system. Then I will give a brief outline of my doctoral research to provide the context of the third part, in which I will focus on the interprofessional dynamics. The Dutch juvenile justice system is applicable to minors in the age of 12 up to 17 years old. It has a flexible upper age limit, but I won't elaborate on that right now because of the lack of time. The Dutch juvenile justice system has a pedagogical character, but is a criminal justice system for minors. This means that the justification for imposing juvenile justice interventions lies in the culpability and criminal responsibility for the alleged offense. But this responsibility is considered to be somewhat diminished, which is reflected in, for example, the less severe sentences. The core objective of juvenile justice in the Netherlands is recidivism reduction, so an offender-oriented approach, but other objectives such as general deterrence, retribution, compensation for victims in society play an important role as well. The main distinction from the adult criminal justice system is its pedagogical approach, which is reflected, amongst others, in the child-specific procedural rules, specialized institutions and professionals, and a stronger focus on positive behavior modification. Well, pretrial detention plays an important role within the context of juvenile justice. Pretrial detention is a coercive measure in the pretrial stage of the proceedings, which the authorities can impose for the purpose of moderating the immediate risk that the accused frustrates the process of truth-finding, absconds, commits another offense, or that his release causes disorder in society, so to bridge the period until the final court hearing. And of course, due to the presumption of innocence, pretrial detention cannot be used as a punishment. Well, when a judge orders pretrial detention of a juvenile in the Netherlands, Dutch law obliges him to consider the possibility to suspend the pretrial detention under conditions. Conditional suspension means that the juvenile will be released out of custody, but under strict conditions and supervision of a youth probation officer. These conditions could be a curfew, restraining order, or an order to participate in a training program, for example. But these conditions should be alternatives to pretrial detention, so they should be less restrictive measures, but with similar objectives as to the pretrial detention which was imposed initially. And of course, these conditions may not have a punitive character due to the presumption of innocence. Well, when we look at pretrial detention in the Dutch juvenile justice system, we see in the literature that the Netherlands is considered to be one of the leading countries in Europe as far as the frequent use of pretrial detention for juveniles is concerned. The UN Committee on the Rights of the Child has explicitly expressed their concern in 2009 about this issue. In 2012, up to 1,581 minors entered the youth custodial institution on a pretrial detention order. And on the 1st of January 2013, 75% of the population minors in youth custodial institutions consisted of pretrial detainees. So a vast majority of minors have already served their sentence at the time that they are convicted. Furthermore, there's a frequent use of conditional suspension of pretrial detention. Well, when we look at the Dutch situation from an international human rights perspective, there appear to be some tensions. For example, if you look at these three norms or principles, that it should only be used as a measure of last resort for the shortest possible period, that it cannot be used to anticipate a custodial sentence, and that the use of alternatives must be carefully structured to reduce the use of pretrial detention rather than widening the net. Well, Against this background, I've started my doctoral research. So the reason was the alleged frequent application of pretrial detention and the alleged differences in application between different district courts in the Netherlands. And well, a possible explanation for this alleged frequent and divergent application of pretrial detention is to be found in the complexity of the judicial decision-making process. This process requires the balancing of different interests. General criminal justice interests, for example, that the juvenile appears in court, the process of truth-finding, but also the personal liberty interest of the juvenile, fair trial interest, among which the presumption of innocence, and the pedagogical interest of early justice intervention, which is considered to be more effective when you intervene in an early stage. And then there's the overall notion of best interest of the child, which should be a primary consideration in all actions in the context of juvenile justice, which has implications for different interests. For example, that it should be a last resort, but it could also be in the best interest of the child to impose a direct intervention. Well, judges have to balance these interests in each individual case, but pretrial detention decisions should always be lawful and may never be arbitrary. Well, this requires for transparent decisions based on a solid legal framework that reflects the function of pretrial detention in the Dutch juvenile justice system and the meaning and interrelation of the different interests at stake. Well, here lies a problem, I think. Dutch law does not provide clear guidance as to the function of pretrial detention and the meaning and interrelation of these different interests. On the level of the judicial decision-making, we have very limited information about the way pretrial detention is applied due to a lack of extensive, solid empirical data. So given these two flaws of on two different levels, in combination with the concerns about frequent use of pretrial detention, it is questionable whether juveniles are sufficiently protected against unlawful and arbitrary detention. So that's the main question of my doctoral research. To what extent are Dutch law and practice regarding pretrial detention of juveniles in conformity with the core human rights principle of protection against unlawful and arbitrary detention? Can this be enhanced, and if so, how? Well, both normative and empirical research methods are used, or legal or normative. So, examining Dutch law and practice in light of international human rights law, conceptualizing the different interests at stake, but also empirical research, qualitative research at 5 district courts, observations and arraignment hearings and subsequent pretrial court hearings, and semi-structured interviews with judges, but also with other professional stakeholders. So far, I've finished my empirical research at 2 district courts in The Hague and Amsterdam. I observed 109 pretrial court hearings in total, and I conducted interviews with 6 judges so far and 7 youth probation officers, so there's still a lot to do. Well, finally, the research objectives: to analyze the judicial decision-making process, clarify the function of pretrial detention in this specific context, develop guidelines which provide insights in the meaning and interrelation of these interests and the function, and eventually contribute to safeguarding a lawful and non-arbitrary application of pretrial detention. Well, now I come to the core of my story, in which I would like to share some of my preliminary findings regarding the interprofessional dynamics. These 5 professional stakeholders are involved at the pretrial detention decision. The examining judge, and in a later stage the court's counsel chamber, who have the authority to order pretrial detention, but only when it's requested by the prosecutor. Well, the accused juvenile has the right to legal assistance by a defense lawyer, and the Child Protection Board and the Youth Probation Officer have an informing and advising role. Well, this figure shows the interaction, the dynamics. First, the prosecutor should request the judge to order pretrial detention. He should do so on the basis of legal criteria, so there has to be a serious suspicion, there has to be legitimate grounds. But before he requests pretrial detention, he should take into account the information provided by the Child Protection Board, which is personal information about the home situation, school situation, etc. Once the prosecutor requested pretrial detention, the Child Protection Board will gather more information to sufficiently inform and advise the judge. When there's a youth probation officer involved, he will inform and advise as well. And often before the first pretrial court hearing, they share information and are in touch to sufficiently give an advice, especially about the conditional suspension of pretrial detention. Of course, these information flows are not one-way traffic. During the court hearing, the judge could urge the child welfare workers to create an action plan or a program for a conditional suspension, which can be used at the next court hearing to reconsider the option to suspend the pretrial detention on the conditions. Well, during the court hearing, there's a defense lawyer. He will often challenge the request of the prosecutor, and could also request for himself to suspend the pretrial detention on the conditions. Well, based on these requests, information, and advices, the judge ultimately takes the decision. But the influence of the other professional stakeholders seems to be substantial. The pretrial detention decision consists of two separate decisions. First, the judge has to decide whether to order pretrial detention, which is primarily a legal question. So, are the legal criteria met? Is there a serious or strong suspicion? And are there legitimate grounds for pretrial detention? So, the risk of reoffending or absconding, etc. Well, it appears, based on my observations and interviews, that the prosecutor has a strong influence on this decision. I'm not doing a quantitative study, but it is remarkable that out of the 109 hearings that I observed, that in only 4 cases the judge rejected the request based on the fact that the suspicion was not strong enough, and in not a single case the judge rejected the request because there were no legitimate grounds. So on the one hand, could mean that the prosecutor does his work very good in his pre-selection work, but you could also question the depth of the review by the judge of the request. Well, then when the judge orders a pretrial detention, he has to decide whether or not to suspend it on the conditions. This is more a balancing of interest, societal interest versus the personal interest of the juvenile. And it seems that the Child Protection Board and Youth Probation Officer have an important influence on this decision. Mainly because the judge has to be convinced that releasing the juvenile is safe and sound for both society and the juvenile, and they heavily rely on the advices of the child welfare workers in this decision. 2 quotes of judges will make this clear. One from The Hague says, "I rarely decide to suspend the pretrial detention of a juvenile when the child welfare workers do not have faith in the feasibility of releasing the juvenile on the conditions." And another judge from Amsterdam, he says, "I want the child welfare workers to offer me a solid action plan which makes the conditional suspension of the juvenile safe and sound before I even consider the suspension." Finally, I would like to focus on the position of the youth probation officer and his tasks and responsibilities. Of course, to advise and inform during the pretrial court hearings, but also to create a tailor-made action plan or program for the suspension. During the suspension, he has the task to provide help, support and guidance to the juvenile, but he also has the supervision, so he can report back to the prosecutor when the juvenile does not live up to his conditions, and eventually the suspension can be revoked. What is interesting is the large amount of discretion during the suspension of the youth probation officer. The youth probation officer has discretion to create the program during the suspension, is flexible to change things, and this discretion is offered by the judge, because almost in all cases that a judge suspends pretrial detention, he imposes the condition that the juvenile should follow all directions of the youth probation officer during the suspension. And well, this discretion is interesting because due to this discretion, the legal or the criminal justice approach to conditions as alternatives to pretrial detention seems to be somewhat abandoned during the execution of the suspension in favor of the approach to conditions as pedagogically effective interventions. One of the judges said, for me, adequate child support has always priority over legal issues. And this is another example of a quote. This is one a youth probation officer from Utrecht who explains how he creates a program for the suspension. And he says, when it's March and the juvenile can start with school in September, you arrange an alternative daytime program for the upcoming months, which also oblige him to arrange his application for the upcoming school year. Because eventually you also look at his future. What is good for him on the longer term. So it's not just bridging the period until the final court hearing, we look beyond the hearing as well. And this is, of course, from a legal point of view interesting, because it's no longer a coercive measure which is strictly limited to the pre-trial stage into bridging the period until the final court hearing. And finally, this is a quote of a youth probation officer from Utrecht as well. And she said, for me, it doesn't feel wrong to impose an intensive probation program to a denying suspect prior to conviction. This program is not just a punishment. Some juveniles just need the strict week schedule of ITB+. So it's a punishment, but above all, it's needed from a pedagogical point of view. Therefore, afterwards, I can't feel sorry for having imposed this intervention when the juvenile is acquitted by the judge, because often it has really helped him. It's a kind of youth support measure as well, because we don't impose an ITB+ if we don't think he needs it. So you clearly see a needs-based approach, and it's interesting that this youth probation officer does not see the presumption of innocence as a limitation on imposing conditions as long as it's in the best interest of the child, of the juvenile. While it is somewhat precarious if you think that the justification for imposing juvenile justice interventions is to be found in the guilt of the juvenile, so you can't just impose welfare interventions from a legal point of view. Well, some concluding reflections. I think the function of pretrial detention is somewhat ambiguous. From a legal point of view, it's a coercive measure strictly limited to the pretrial stage, to bridge the period until the final court hearing, to moderate risks, short-term risks. But in practice, due to the role of the child welfare workers, to a large extent, I think, conditions and the conditional suspension seem to also be used in a pedagogically effective way, which makes the function of this alternative entirely different. And with this in mind, on a more abstract level, it might give reason to question the character of Dutch juvenile justice. Is it really a criminal justice system for minors, or is a child welfare approach paramount? Well, I think it's a multidimensional system, a mixture of justice and welfare approaches and practices. And I think that it's actually the dynamics between the legal professionals and the child welfare workers that create such a multidimensional system to a large extent. And I think that the case of pretrial detention and alternatives to pretrial detention is a clear example of how this works and how this is created. And now I'm very interested in your remarks and questions.
Thanks very much.